Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Kyle Nazareth, the Marketing and Content Manager at Napa Legal.
Thanks for joining us for another episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it. If you like the podcast, subscribe to our channel on YouTube, Spotify, or wherever you're listening from. The more we have supporters who are tuning in and engaging, the more we can do this. So thank you in advance. All right, this week we're covering first a Maryland lawsuit over a law barring firearms near houses of worship. Then we'll go to another Ten Commandments case out of Texas. And then we'll wrap up with a brief discussion of the new Massachusetts law that most of you have probably already heard of that removes nearly all restrictions on abortion within the state. So let's start in Maryland. This one is fascinating. There are a couple different lawsuits going on. We'll talk a little bit about the different tracks on which this law is being challenged. So Maryland state law currently limits situations in which local counties or municipalities can pass firearms regulations, right? This is pretty common. If a state says these are our gun laws, they'll also often have laws saying that, localities, cities can't pass additional restrictions other than what the state laws require. That's not always the case. For example, in my home state here in Pennsylvania has reasonably permissive gun laws for the most part, but Philadelphia has additional regulations around the carrying of handguns that don't apply in the rest of the state. So sometimes you do see these things where localities, counties can have additional regulations. So in Maryland, one of the permitted local regulations that counties or municipalities can have is they may enact regulations prohibiting firearms from being carried within a certain distance of houses of worship. So Montgomery County recently did just that. They set a barrier saying that firearms cannot be carried within 100 yards of a house of worship, and that triggered the current lawsuits, plural. So the lawsuits are interesting, first of all, because there's more than one. So there are two separate lawsuits that I've been following. I think, Kyle, you said there may be a third one from some nonprofit, but I'm focusing on the two main ones. There's a lawsuit filed by the Second Amendment section of the Department of Justice Civil Rights Division. So they're actively involved in prosecuting this lawsuit against Montgomery County purely on Second Amendment grounds. And then an Orthodox Jewish synagogue has also filed a lawsuit alleging the law violates their rights under the Second Amendment, but also the First and 14th Amendments on religious exercise grounds. I think the legal claims are pretty interesting because the First Amendment and Second Amendment claims are quite different lines of attack, and I think they're both pretty strong arguments. The Second Amendment are less novel. The First Amendment is something we don't see as much, so I'll be kind of interested to see how this goes forward and which claims the courts actually end up settling these on. So first of all, I'll say the Second Amendment claims in these cases, they go beyond what we normally cover on this podcast. We're not a guns rights organization, but I still know a bit about this area of law and want to talk about it because it's relevant in these cases. Listeners probably know that Second Amendment claims are now adjudicated based on a history and tradition test that was articulated in the 2022 Supreme Court case called Bruen. Again, I'm not an expert, but I have written a little bit on this. So my understanding, to paraphrase Bruen, is that basically if governments are enacting firearms restrictions, for those laws to be consistent with the Second Amendment, they have to show that at the time the Second Amendment was ratified, there was an analogous restriction on firearms that was permissible at the time, right? So it's a tricky analysis, I think, as we can obviously see the problems or the difficulties there, right? New circumstances, new technologies, the world is a different place. The size of cities, the firearms technologies makes it often fairly difficult to find a history and tradition analog, right? These difficulties come up, it's pretty obvious to think of hypotheticals or real situations, right? When courts are trying to evaluate a ban on, an automatic weapon or an extended magazine, other firearms and accessories that just didn't exist in the founding era. When you're talking about, bans and buffer zones and things like that in major metropolitan areas that are, have millions of people living in them. Again, it's just kind of hard to find a founding era corollary because we didn't have these technologies. We didn't have cities with 8 million people living in them. So again, I'm not an expert, but it can be a complicated analysis. But I think here, this one's a bit different, because I would venture to guess that defenders of this law will probably have a hard time coming up with historical laws in early America that prohibit firearms from houses of worship. Firearms existed in the founding era, so did houses of worship. So we're not looking for some anachronistic comparison, right? Either these kinds of laws existed at the time of the founding or they didn't. And I also would say that it's an interesting historical fact that wouldn't decide this case, but I think it is worth pointing out that not only I'm not aware of any laws that restricted firearms from houses of worship in the founding era, but there were several states in the colonial pre-Constitution and then in the early founding era that did the exact opposite. You'll see, I think there are like 3 states that I found that actually required able-bodied men to carry firearms to church in order to defend against, hostile enemies, invaders, and other threats in the church. So again, I'm pretty skeptical that there are going to be, laws that defenders of this law can point to that say, oh yeah, in the founding era, this is quite consistent with the Second Amendment banning guns from houses of worship. I just don't think so. But putting aside the Second Amendment argument here, which again, I think it's a strong argument, but it's not exactly in our wheelhouse. There's also a very relevant religious freedom issue going on in this case. And that comes up in the lawsuit that this Jewish synagogue in Montgomery County filed. So the synagogue argues basically that the law is, first of all, not facially neutral and generally applicable, which, as all listeners of this podcast know by now, has implications for our free exercise jurisprudence, right? If a law is facially neutral, generally applicable, applies to everyone, no exceptions, then it doesn't have to pass strict scrutiny, even if it does in fact burden religious exercise. The synagogue argues, I think rightly here, that this is clearly not a facially neutral, generally applicable law because it's singling out a place of worship, right, a religious practice, as one of the restricted areas where firearms are prohibited. So it's not a law just saying, no guns within 100 yards of any place that has more than 50 occupants or something like that. That would probably be a stronger argument that it's neutral and generally applicable. This clearly targets a religious place. And so the plaintiffs claim they have a sincere religious belief that Jews must be prepared to defend themselves and other Jews, and that they should perform this responsibility personally rather than outsource it to others. So religious exercise claim to be able to defend themselves in their houses of worship, and a correct claim that this is not a generally applicable law, but is explicitly targeting religious groups here. So I think this is fairly obvious. So being that it's not a generally applicable law, I think strict scrutiny will probably apply here. And then I think it'll be interesting to see how this First Amendment analysis, well, First Amendment, 14th Amendment, right, because it's incorporated against the states. So you have the compelling interest question and then the narrowly tailored, least restrictive means analysis. Depending on, this is a big problem with compelling interest, right? What is the interest, the compelling interest the government has? Of course, they can say we have a compelling interest in preventing gun violence generally, right? That's so broad that, of course, that's going to be a compelling interest. But you have to, I think, be more specific in articulating a compelling interest. Like, what is the compelling interest in doing this particular thing, in banning guns from a place of worship? Who does it affect? What are you really trying to do? Prevent gun violence is so vague as I think to be pretty unhelpful. But regardless, even if the government can articulate a compelling interest that passes muster here, to me, the question is about the narrowly tailored, least restrictive means of accomplishing the compelling interest. That's the analysis that matters here. And I would say if preventing gun violence at places of worship is the compelling interest, I'm skeptical that this law would accomplish that interest at all, let alone in the least restrictive means way possible, right? If you did again, I haven't looked at the research or the statistics here, but I think it's pretty safe to say that gun violence that happens in houses of worship comes from outside the community, right? Not from the people who are worshiping. I think it's pretty unlikely that the goal of such a law is, well, to prevent members of the religious congregation from suddenly committing acts of violence against their own people, right? The articulatable interest must, I think, be preventing attacks in the synagogue, likely from outside. And so I think restricting law-abiding worshipers from carrying firearms in their own house of worship actually works against that goal, right? Because what's the practical effect? I don't mean to get political, but just as a policy and common sense um, conversation, right? What you're doing is if you say this is a buffer zone, right? We have a law that says nobody can carry a gun within this place. It means most or all law-abiding citizens are going to follow that law, which means most or all of the worshipers in that house of worship are not carrying firearms, which I think means that you're telling any would-be attacker that he's entering a place of worship where the worshipers are unarmed, right? So I don't see how this prevents gun violence in houses of worship. I actually think it makes the places more dangerous because if some deranged person decides they want to go shoot up a house of worship, they know that they're entering a place where they will not encounter armed resistance. And so I think it's problematic. I don't know how you can argue that, we have a compelling interest in preventing gun violence, and by disarming worshipers in their places of worship, we're helping to accomplish that in the most narrowly tailored way possible. I think it's a hard argument. And it'll be interesting to see how this goes forward. Again, I've never analyzed a free exercise case involving guns. I've never analyzed a gun case on this podcast at all. So for me, it's a case of first impression to deal with. I'm also practically interested in seeing how the court actually settles this case, because I think the more likely route may very well be to stick to the Second Amendment issue and declare that this law is unconstitutional because there's no historical analog, and that this is an impermissible restriction on the Second Amendment. So I'll be curious to see if the First Amendment argument even goes forward, or if this ends up being a straight Second Amendment argument. But regardless of how it's resolved, this is one to keep an eye on. Kyle, anything to add here?
Not too much. I was just really fascinated to hear that when reading the complaint that Jewish law requires Jews to defend themselves when necessary, albeit with guns. That was like a fascinating kind of thing to see, and it was an interesting kind of confluence of First Amendment, Second Amendment grounds that they're bringing this on. It's pretty rare to see, so interesting bedfellows. And I think you're right that it'd probably be more cleanly resolved on Second Amendment grounds, but it's also really fun to see a novel case like this. So interested to see where this goes. And then moving on to our second case, this one's about Texas parents shifting from Establishment Clause arguments to free exercise clause arguments in the latest lawsuit against the Ten Commandments in schools and public schools in Texas. So the name of the case is Roth versus State of Texas, and the background for it is pretty much the same as the Nathan versus Alamo case, which we've discussed previously on the podcast. I don't want to belabor the point, but just to touch on it quickly. Last year, Texas passed a law requiring all public schools to display the Ten Commandments in their classrooms, public school classrooms. And there's no commentary or teaching required by the teachers. It's just the text on a poster of the Ten Commandments. And challengers came claiming that the requirement violated the Establishment Clause and Free Exercise Clause. But the Fifth Circuit Court of Appeals said, no, that's not true. And in an amazing comprehensive opinion by Judge Kyle Duncan that everyone should go read, the Fifth Circuit relied on Kennedy versus Bremerton and required federal courts to ask whether challengers using an Establishment Clause argument have proven a set of facts that would have historically been understood as an establishment of religion. So we're going back to history and tradition, and it draws a lot on the scholarship of, a renowned First Amendment religious liberty scholar, Professor Michael McConnell, when the Fifth Circuit said that for an establishment to exist, an establishment of religion, there's 6 hallmarks of founding era establishments, which we have to analyze. And I won't go into each one of them, but basically Judge Duncan concludes that SB 10 looks nothing like a historical religious establishment. It does not tell churches or synagogues or mosques what to believe or how to worship or who to employ as priests, rabbis, or imams. It publishes no one who rejects the Ten Commandments, no matter the reason. It levies no taxes to support any clergy. It does not co-opt churches to perform civic functions. These would be the kinds of things that establishments of religion did at the time of the founding, but SB 10 doesn't do any of those. So, in conclusion, the court found no Establishment Clause violation. And then second, the plaintiffs also brought, or the appellants in this case, also brought free exercise arguments, and they relied really heavily on Mahmoud versus Taylor, where the Supreme Court held that parents could opt their children out from public school instruction that they believed violated their free exercise rights. But the Fifth Circuit found no conflict with Mahmoud, and Judge Duncan said to the plaintiffs that merely exposing children to religious language is enough to make displays engines of coercive indoctrination. But the court disagreed, and they said that the curriculum in Mahmoud went far beyond books sitting silently in classroom shelves. Those materials were deployed by teachers with lesson plans designed to subvert children's religiously grounded views on marriage and gender. And SB 10 doesn't do any sort of that kind of thing, right? This is a passive poster of the Ten Commandments that's much different than a teacher actively teaching LGBT curriculum in a classroom. So, on free exercise grounds, the Mahmoud case is distinguished on that front. So although the Ten Commandment challenges in federal court failed, this time they're being brought by new challengers, three mothers. And well, it's interesting to go through who the actual mothers are. Mrs. Roth, I'm not sure she is using a religious establishment argument or free exercise argument. But one of the plaintiffs, Sanjam Sohal, is a Sikh, and the other one, Audrey Nath, she's raising her children according to multiple religious traditions, including Jainism, Hinduism, Judaism, and Quakerism. That's an interesting mix there. But they're trying in state court this time using the Texas Religious Freedom Restoration Act. And for those who don't know, that prohibits government from substantially burdening free exercise of religion unless it advances a compelling interest by the least restrictive means. And they're also bringing this suit under the recently adopted Parental Rights Amendment to the Texas Constitution, which protects parents' fundamental rights to direct their children's upbringing. And the basic upshot of these arguments is that they're claiming that the Ten Commandments posters compel their children to confront a religious message that conflicts with family instruction, and therefore it burdens their free exercise and parental authority. And that's really the question I want to talk about here. Whether just because children see religious messages that may conflict with their family's religions inside a classroom, is that coercion? Well, the plaintiffs believe there is, and they're making the same argument that was made in the dissent in the Alamo case, basically arguing that the Supreme Court's long history of heightened concerns with protecting freedom of conscience from subtle coercive pressure in elementary school and public schools is very important. And the dissenting opinion where they're drawing this argument from really cites Lee versus Weisman, the 1992 Supreme Court case, where a divided court ruled that including prayers from a rabbi at a public school graduation was psychological or religious coercion because students felt compelled to stand during the recitals. But quite frankly, that opinion is just wrong. Justices Scalia and Thomas have correctly defined religious coercion in the historical traditional sense, and it's much more narrow than the dissent in Alamo says. Justice Scalia and Thomas have said that the coercion that was a hallmark of historical religious establishments was coercion of religious orthodoxy and of financial support by the force of law and threat of penalty. So it's actual legal coercion that counts. The examples might be like being jailed for not going to mass on Sunday, or a public tax on citizens to pay for Christian ministers in religious education, right? That's what happened and was that controversy in the James Madison's Memorial and Remonstrance. Not the idea of religious coercion in our founding kind of context was not subtle coercive pressures or psychological coercion. And while we're throwing around those terms, what does psychological coercion even mean, really? I mean, these are boundless, manipulable tests with no principle limit, right? It's really a judge putting themselves in the mind of the plaintiff and saying how far that kind of coercion goes and how they'd feel about it is basically where the line gets drawn. And this raises the offended observer problem that the most sensitive listener in the room sets the constitutional floor, which this effectively creates a right to not be uncomfortable around other religions. That doesn't sound to me like what should be the case in a pluralistic society. And going back to this case, the Roth case, here the students aren't forced to do anything or believe anything under the penalty of law. The Ten Commandments are just a poster that they passively see every day. And this is the same exact point that the Fifth Circuit makes, and it's why the court in the Alamo case distinguishes the West Virginia State Board of Education versus Barnett case, the 1943 Supreme Court case, where public school students who were Jehovah's Witnesses were permitted not to salute the flag or say the pledge as instructed by their parents. And that's because that's an active participation. forcing students to stand up and put their hand over their heart and, actively kind of engage in that practice was seen as coercive and against I think it was, the Jehovah's Witnesses' religious belief at that point. But here, there's not any sort of that participation. And just for listeners out there who might think this is a political stance agreeing with Justice Scalia and Justice Thomas, well, as Catholics, we're also very sensitive to and deeply concerned with the idea of religious coercion. Vatican II's Declaration on Religious Freedom, Dignitatis Humanae, says that human dignity requires that people act on their own judgment out of duty about religion rather than compulsion. And also just listen to how the Council defines religious freedom, that all men are to be immune from coercion on the part of individuals or of social groups and of any human power in such wise that no one is to be forced to act in a manner contrary to his own beliefs, whether privately or publicly, whether alone or in association with others within due limits. So while the church is extremely concerned about religious coercion, I think actually church teaching on this matter synthesizes very well what Justice Scalia and Thomas have said and the Fifth Circuit have said. Because the sentence that it really says about coercion is that in such wise that no one is forced to act in a manner contrary to his own beliefs. So even Vatican II says coercion is about action. It's not about passive or extremely subtle and psychological coercion. That's not what Vatican II talks about. And in this case, the Harris County judge denied an emergency temporary restraining order on August 7th. A preliminary injunction hearing scheduled for today, actually, the day this is being recorded, August 17th. So we're going to wait and see what the result of that is.
Yeah, just a couple notes about these lines of attack and how they're changing, right? Because as we saw from the Nathan versus Alamo Heights case, especially in the Fifth Circuit, after Judge Duncan's opinion, you're probably not going to get an opinion that says that the posting of the Ten Commandments violates the Establishment Clause. So hard to make a federal First Amendment case. So now litigants are changing to state constitutional arguments. It's interesting here. They don't use the Texas equivalent of the First Amendment, which is worded differently. I think it's Article 1, Section 6 is their religious liberty bit. It's not worded like the federal First Amendment, but I think it would be shocking for, Texas courts to interpret that their state constitution prevents the Ten Commandments from being posted when the federal First Amendment does not. So it's interesting to see the different opportunities that litigants are trying to take, right? You mentioned that they sued here under both RFRA and the new Section 37 parental rights constitutional amendment in Texas. So I just note quickly that, right, RFRA, the Religious Freedom Restoration Act, requires a substantial burden on religious exercise in order to trigger strict scrutiny to strike down a law. First of all, sorry, but there's no burden on your religious exercise at all to say that, there was a poster with the Ten Commandments on it in a classroom. And even if you find that this is some incidental burden on your religious exercise to have that up, no way in my mind this rises to the level of a substantial burden, right? Like these things are more commonly challenged as Establishment Clause issues. You're establishing a religion, but to say that this is impeding someone's free exercise of religion in a substantial way to see a poster, again, it gets back to the offended observer thing that you were talking about, Kyle, and applying it to religious exercise claims, I think is frankly absurd. And then the parental rights argument is interesting. So I'll just read their constitutional amendment here. The Texas Constitution says, to enshrine truths that are deeply rooted in this nation's history and traditions, the people of Texas hereby affirm that a parent has the responsibility to nurture and protect the parent's child and the corresponding fundamental right to exercise care, custody, and control of the parent's child, including the right to make decisions concerning the child's upbringing. Now, obviously, it was a federal First Amendment case in Mahmoud and was not interpreting a Texas, recent constitutional amendment. But as Justice Alito pointed out, you can use the reasoning here, right, in Mahmoud. The LGBT books that were at issue in that were not simply, for one, they weren't just sitting on a bookshelf. They were part of the curriculum. And for two, they were not simply informational. They were normative. They were saying, this is good. You are going to accept this way of marriage, of child rearing, all of that stuff. It was a very ideological, didactic thing that children were forced to undergo in schools, I can't see any serious argument that placing a poster of the Ten Commandments somehow violates the rights of parents to make decisions concerning a child's upbringing. It's not a major part of the curriculum. In fact, it's not a part of the curriculum at all. It's a poster. So I just don't see it. I don't see either one of these arguments gaining traction. But all that being said, I would expect to continue to see these if the First Amendment arguments fail. And Nathan versus Alamo Heights is, I think, pending before the Supreme Court, or maybe. But even if we get a decision from that, I expect that we'll continue to see various attacks on state law grounds to try to find alternate ways to keep these, offensive, coercive posters from being displayed without commentary in schools. So more to come, I'm sure. All right. Last issue. This is not as much commentary because this is not legally complicated, just horrifying. The governor of Massachusetts, who is an outspoken Catholic, signed into law the so-called Act Prioritizing Patient Access for Care. This was House Bill 5595 on August 10th. So the law eliminates the state's four-part framework for abortion at or after 24 weeks, replaces it with a single standard. An abortion may be performed based upon the professional judgment of the physician, and that now applies at any stage of pregnancy, including after 24 weeks, so into the late term. So the law, besides doing this, also bars medical review processes by teams at these health networks from overriding the treating physician's judgment, strengthens the state shield law protecting providers from out-of-state investigations about abortions. The law will take effect in November. It's a 90-day window. As I mentioned, the prior statute permitted post-24-week abortion only in certain situations to preserve the woman's life, physical or mental health, or in cases of lethal fetal anomaly or a diagnosis incompatible with sustained survival, right? So cases where a child is diagnosed as having no real chance of surviving after birth. Those restrictions after 24 weeks are now essentially gone. And with that, Massachusetts becomes one of about 10 states without any statutory gestational limit on abortion. There has been some initial backlash. The 4 Catholic bishops in the state of Massachusetts, through the Massachusetts Catholic Conference, wrote last month, called the elimination of legal restraint on late-term abortion a radical measure which is gravely immoral. Archbishop Henning called the law a grave offense against the sanctity and dignity of every human person, rightfully so. The head of the SBA, Pro-Life America organization, Marjorie Dannenfelser, released a statement recently urging Republican politicians in particular to abandon the leave it to the states position and favor national protections for unborn life. There's a lot of criticism coming out. And again, the law is what it is. It's bad. Every abortion is the killing of a human life made in the image of likeness of God. So yeah, but I want to say a couple things about the principles and some of the challenges around these horrific permissive abortion laws and what I think we can and really can't at this point do from here. So first of all, the so-called moderate position taken by many Americans today, right, that late-term abortion should be rare or illegal, which is right, illegal, but that early-term abortion should be allowed is really quite illogical. That is kind of the prevailing sentiment in the middle. But as we see from science and logic, nothing happens at any magic point, right? Whether that be when the baby has a detectable heartbeat or some arbitrary limit like 15 weeks gestational age or 24 weeks or third trimester or whatever, that turns the unborn child from not a child into a human child with rights. So there's just no way you can draw the line in any sense that is not arbitrary. Some of this might be optics that creates comfort or discomfort with people who aren't really thinking philosophically about this, right? An older baby at 24 weeks looks more like a born baby than, a 2-week-old embryo, but it's the same creature being killed, right? Whether the baby's 2 weeks old or 30 weeks old. And I would also say that tragically, the reality is, well, I mean, it's tragic that this ends up being the case and is so hard to deal with. Relatively few late-term abortions even occur these days. Like, they happen, and that's horrifying, but with earlier pregnancy detection between tests and ultrasounds and the wide availability of abortion drugs, in particular mifepristone and the follow-up drug, studies show that about 2/3 of abortions now are chemical rather than surgical today. So while obviously these barbaric late-term abortion laws should certainly be opposed when permitting these kinds of practices, actually stopping abortion does require tackling the major issue that a baby is a person at any gestational age. And the main method of abortion today, the abortion pill, is the primary problem. So again, not saying you shouldn't do anything or react to these, allowances for late-term abortion, but the reality is, if you care about the killing of unborn human life, most of these are not happening in these late-term surgical abortions. It's happening by pill. It's often happening without a doctor, by mail, and it's happening by the millions. So these things are important to attack, both to educate people about the evils of abortion and just because we should be preventing abortions whenever we can, but they're not the main source of abortion, especially in the modern age. The second thing I'll say, so Marjorie Dannenfelser here and then the other anti-abortion advocates fighting about this are of course correct, right? That the relativist position of leave abortion to the states is deeply problematic, right? Legalized abortion should be opposed because it allows for the murder of innocent citizens, babies. It's not a federalism issue that should be left to the states to decide, because states shouldn't be able to decide to have their innocent citizens murdered, regardless of the democratic realities. That said, I'll say for myself personally, I'm an abolitionist in theory, but an incrementalist in reality. And I think this is just the nature of where we are, right? If I could flip a switch, there's nothing I would rather accomplish than to stop every single abortion from happening. But I think now this is primarily a cultural rather than a federal, political, or legal issue, just for realist feasibility issues. So Ryan Anderson and I had a dialogue about this a few months back around the March for Life in January. I think he makes the argument pretty convincingly that pro-life anti-abortion advocates, we should be advocating for whatever policies prevent as many abortions as possible, and those that can actually survive political and legal backlash. So yeah, I'd love to see a federal abortion ban, but sadly, there's no political appetite for this, not even close at the federal level. Hate to break it to abolitionists, but I don't see these things passing or sticking in the current climate. So just to give you a sense of how far we are on this issue, the last poll that I've seen was I think it was 2024, a Pew Research poll. I'm citing from memory, but it showed that even among Republican voters who tend to be more opposed to abortion, there's barely a majority of Republican voters who responded to this poll and said they were in favor of banning most or all abortions. I think it was like 57% of Republican voters polled. So then when you add in Democrats and non-affiliated voters, there's nothing close to a majority that are in favor of serious abortion restrictions at the federal level. So if through the political process, proposing a federal abortion ban, right, by a congressman or a senator has no chance of passing, what does it do? It makes the politician proposing them vulnerable to losing an election, yes. The law has no chance of passing. So I don't know with political prudence how that's a feasible strategy to end abortion. I understand the educational need to use laws to instruct people about what's good and what's bad, but when the voting populace is not even close on this issue, I don't know that that's really a viable stance if your goal is to actually stop abortions. I don't see what it will do at this stage. And I hate that reality, but I think it is the reality. And then on the legal level, I've read quite a bit into this, and I think in principle, I agree with the theory that an unborn child is a person under the 5th and 14th Amendment. And if that's the case, and if the Supreme Court ruled on such an issue, again, I don't think we have 5 votes there at all, but if they did, right, if all of a sudden an unborn child in the womb is a person for purposes of the Constitution, then unborn babies can no longer be deprived of the right to life without due process of law, right? Which would effectively make all abortions an unconstitutional deprivation of life overnight, right? That ruling on personhood under the 14th Amendment would be a just law. It would end abortion. But I worry that this kind of a decision, again, I'm stealing this from Ryan Anderson from a talk he gave back in January, but that such a decision would be so unacceptable, though just, to the American people today, that there's a good chance there would be legal backlash, that such a Supreme Court ruling would actually trigger a movement to pass a constitutional amendment enshrining abortion as a constitutional right. And then the situation we find ourselves in is actually even worse than what we have now. That's a speculation, but I guess my caution is that the pro-life anti-abortion movement needs to think very carefully about what policies will actually prevent abortions from occurring, and that we be careful not to support political or legal efforts that are basically grandstanding, but that are not going to hold and that are going to create reversals and actually worse results than before. And this is a hard cultural truth to swallow, but 49 years of telling the American people that abortion is a constitutional right, from Roe in 1973 to Dobbs in 2022, coupled with a serious loss of religious faith in this country, has put the pro-life movement in a bad place, right? People are used to abortion as an option. That's real. They might be uncomfortable with it, at least in some practices, but they don't tend to like the idea of complete abolition, of severe restrictions. And we've seen this play out in the political realm in recent years, right? When faced with the decision between ban most or all abortions and allow most or all abortions, people are choosing the latter, even in generally conservative states, right? We saw the referenda in Kansas was 2022, right? Ohio was 2023. They didn't go well. And these were put directly to the people. So yeah, we should be prudently fighting for every political and legal solution that stops abortion. But I think we do need to acknowledge that the fight right now has to be on every front, but it's primarily going to take place in the churches and in the culture to actually create a citizenry that understands that abortion is unacceptable and gravely evil in all circumstances, that understands that the taking of innocent human life made in the image and likeness of God is a problem in all situations. Until we do that, I fear that our political and legal solutions to the scourge of abortion are pretty limited.
I couldn't agree more. And that just brings to mind the importance of kind of not just political recourse or even legal recourse, but a reminder to especially Catholics that there's also a spiritual recourse for some of these things. The church teaching on abortion is very clear. Abortion is evil. Catholics cannot support it. And I think Pope John Paul II's Doctrinal Note on some questions regarding the participation of Catholics in public life that he published in 2002 is very clear and explicit in these kinds of situations involving politicians who support abortion. He says, those who are directly involved in lawmaking bodies have a grave and clear obligation to oppose any law that attacks human life. For them, as for every Catholic, it is impossible to promote such laws or to vote for them. So a Catholic legislator who supports procured abortion, they know the teachings of the church, and they manifestly commit this grave sin by supporting it, especially of signing a law that makes it more accessible up to the point of birth, right? That's extreme scandal to others. And according to the Code of Canon Law, Canon 915, they are not to be admitted to Holy Communion. I know we're the Napa Legal Podcast, but we can throw in some canon law, I think as well. I think that falls under the realm of Napa law. But so groups like Catholic Vote actually are starting to raise these questions, bring up canon law, and ask if this Massachusetts governor, Maura Healey, whether she's been late sensentiae excommunicated. They cite like Code of Canon Law 1397 about a person who actually procures an abortion and cures a late sensentiae excommunication. I'm not going to say that word anymore. The Latin's a little too over my head. But they also cite Code of Canon Law 1329, which is kind of raising a theory of like being an accomplice. And if that person could have but for that person helping, the person who actually committed the abortion could not have procured it without them, right? Then that's equally as wrong and attributable to this governor who enabled and signed this legislation. And I think this whole situation kind of brings me back to the courage and kind of doctrinal clarity that Archbishop Cordileone showed when he denied communion to Nancy Pelosi. And I think in this situation, I just really hope there's further doctrinal clarity in the future as well.
Yeah, one more thing I'll say on the excommunication point, right, is that obviously we're not just using this to score political points. Like, Maura Healey is is, opposed to our positions on life and all these things, so we want to beat her down with an excommunication. But there are real pastoral as well as justice-based reasons to be in favor of these kinds of measures. And for one, for her own soul, right? Somebody who is holding herself out as a public Catholic, which she does, and then is supporting things that are gravely evil and opposed to the teachings of the church, needs to be publicly reprimanded for two reasons. One, because I think pastorally the church can do the charitable thing, which is to show her we take this seriously. You're opposing church teaching, and then give her the opportunity to realize how high the stakes are, that she needs to reconcile with the church in the way that she's conducting herself as a public official. And then you need to prevent scandal. I mean, it's a huge problem if you have somebody going out there very publicly saying, I'm a practicing faithful Catholic, and I'm signing one of the most hideous pro-abortion bills in the United States. The Catholics, especially not well-formed Catholics, need public signs that this is not okay, right? Lest they be led into the same thing, into thinking that they can support abortion and be, good, devout Catholics. So I think those kinds of excommunications are really important teaching opportunities for the Catholic faithful, as well as opportunities to invite people who are doing things contrary to the teachings of the church to reconsider and to repent. And with that, we thank you for joining us for another episode of the Napa Legal Podcast. So we hope you'll join us next week as we continue to highlight and discuss the most important ongoing legal issues that affect religious liberty, and particularly the work of faith-based nonprofit organizations. We'll talk to you next week. Thank you for joining us, and God bless you.